BIS Benefits. We are an employee benefits firm located just north of Atlanta in Alpharetta, and we serve about 275 businesses and organizations, assisting them with their employee benefits, including medical, dental, life, vision, disability, wellness, and other key group benefits. To learn more about us, you can find us on the web at bisbenefits.com, or you can follow us on Twitter at BIS Benefits. But today, we are pleased to introduce you to an expert on healthcare reform from Proskauer. Proskauer is a top 50 global firm with more than 700 attorneys across the country and throughout the world. There are more than 60 attorneys who practice exclusively in employee benefits and executive compensation law at Proskauer. Our speaker today is Stacy Barrow. He is a member of his firm's Employee Benefits and Executive Compensation Group and its Healthcare Reform Task Force, and he is ready to present to us on the Affordable Care Act's requirements for 2012, 2013, and 2014. So, Stacy, thank you for being here, and let's get started.
Great. Thanks, Jack. Good morning, everybody. This is Stacy Barrow from Proskauer in Boston, and I'm an employee benefits and executive compensation attorney here at Proskauer, and we are proud to partner with BIS to offer today's webinar. As Jack said, today we're going to cover the Affordable Care Act and what comes next for employers. I'm going to start by giving a very brief summary of the Supreme Court's ruling and how that affects employers. We'll talk about some of the current mandates and market reforms that are in effect in 2012 and coming into effect in 2013. Then we'll talk a little bit about the individual mandate and the exchanges, just so we understand the underpinnings of the employer mandate, and we'll spend a little more time on the employer mandate, and then we'll end with some employer considerations and questions. So as you know by now, the Healthcare Reform Act was largely upheld by the Supreme Court. However, they did strike down a Medicaid expansion provision, and that's going to have potentially some impact on employers, depending if they are in a state that has chosen to expand Medicaid or not. I'll explain that in a few minutes, but all of the insurance mandates and market reforms remain intact based on the Supreme Court's decision, so employers have to continue to implement those mandates and continue to get up to speed with healthcare reform. We do expect there will be some challenges in the future. That Supreme Court case won't be the last court case involving healthcare reform. We've already seen a number of First Amendment challenges with respect to the preventive care requirements. We have some religiously affiliated employers that are challenging the Healthcare Reform Act's preventive care requirements on First Amendment grounds. There are at least 4 lawsuits that are currently in effect right now. I think 3 of them may have been dismissed due to lack of ripeness, but at least one case has been decided at the lower level. Well, there was at least a preliminary injunction granted by a court in Colorado to a private employer that challenged the expansion of the Women's Protective Services under healthcare reform. So we do expect that there will be some other challenges on that front. And there may be some challenges related to the exchanges as well. In a state that doesn't establish a state exchange and has the federal government come in to establish that exchange, there's a question as to whether the premium subsidies from the government can be used at a federal exchange rather than just a state exchange. And this is important because the federal premium subsidies that employees can receive are the gateway to the employer mandate, meaning that there cannot be a penalty under the employer mandate if your employees do not receive a federal premium subsidy. I'm going to get into all those rules a little bit later, but the bottom line is we expect to see a little bit of litigation there. So I mentioned before that the court struck down a provision of healthcare reform that expanded Medicaid. Essentially, as it stands right now, the states essentially cover individuals with income below 100% of the federal poverty level. Healthcare reform extended that to 133% of the federal poverty level, and it's really more like 138% of the federal poverty level because there's an additional 5% income disregard under PPACA. So this was a huge expansion of Medicaid, and the failure of the state to comply with this Medicaid expansion would have been the loss of all federal funds. And the court struck that down as being unconstitutional. Scalia essentially said it was the equivalent of putting a gun to the head of the states, and that an expansion of this magnitude was different than all the other Medicaid expansions in the past that survived the constitutional challenge, because it so greatly expanded the program, it was almost akin to creating another program on top of Medicaid. So at any rate, the court said that the states don't have to expand Medicaid, and this may have an impact on employers. Specifically, it may increase exposure to a penalty under the pay or play mandate. So how does that work? So I mentioned before that states were going to expand Medicaid eligibility from 100% to 138% of the federal poverty level. So all of those individuals between 100 and 138% would have been eligible for Medicaid. If the state doesn't expand its eligibility, then all of those individuals are the types of folks that may qualify for a federal premium subsidy, and therefore they could trigger a penalty on the employer. So as an example, if we take someone at 120% the federal poverty level, he's obviously between 100 and 138. He's going to be eligible for a federal premium subsidy if his state doesn't expand Medicaid eligibility and the employer fails to provide quality, affordable health insurance coverage. And we'll talk about exactly what those standards are in a little bit, but here is a map of the states that challenged Medicaid expansion. You can see Georgia is one of those states, so it's certainly a possibility that Georgia will decline to expand Medicaid, and therefore Georgia employers may potentially be subject to a greater likelihood of having a penalty imposed under the individual mandate, just because there'll be a greater number of employees that could potentially qualify for a subsidy instead of Medicaid. Some other considerations that we've noticed in the last couple of years in light of healthcare reform, we've seen audits increase by all of the regulatory agencies, DOL, IRS, and HHS. The DOL has already added grandfathered status as one of its audit items on its checklist. So the DOL wants to know the plan design during any period during which the plan was grandfathered, and it also, the checklist also wants to know the plan design during periods where you weren't grandfathered. So either way, there'll be some increased reporting here. You may end up getting a little more familiar with your regulatory agencies. But the good thing is that at least in the early years of compliance with all of these mandates, the DOL is really focusing on increasing employer compliance rather than simply just assessing the penalties as a first line of attack. So where basically, a good faith reading of the regulations should go a long way, and hopefully any good faith interpretation will be respected by the DOL.
Hey, Stacy, there was one quick question when you mentioned the federal poverty level. Do you have a reference to what that level actually is, what that number is?
Sure. It is based on family size, so it's a little hard to tell. I think it's the 100% of FPL, I believe, is around 15,000 for a single and around 40,000 for a family of four. And for 400% of the federal poverty level, it's about $90,000 for a family of four. So the bottom line is that I think a great many employers will have employees that are under 400% of the federal poverty level if they're in a family. So, folks that you wouldn't normally think might be eligible for some premium assistance might in fact be eligible for that assistance. I know that you can Google the FPL, and you'll get a table that will show you, based on the percentage of the federal poverty level and your family size, a little more precise numbers. So just another very quick word about additional litigation concerns for employers. There are potential concerns with workforce realignments under health care reform. When talking to employers, particularly ones that will be affected by the employer mandate, those with a lot of variable hour employees, like employers in the hospitality industry or construction industry, certain industries may have a greater likelihood of triggering this employer mandate. And so employers have indicated they may realign their workforce, in other words, limit the hours of their employees to under 30 hours a week in order to avoid this mandate. And just keep in mind that whenever you engage in a workforce realignment like this, we do recommend that you consult with counsel, just because there are some federal laws that impact workforce realignments, and you want to be careful how you communicate this to employees. We've heard of a number of employers seeking to exit the retiree medical market and potentially put those retirees into the exchanges to the extent they're pre-65 retirees. Anytime you're amending or terminating a retiree medical plan, again, we always encourage you to talk to counsel. And we also expect there'll be some other claims related to mandated benefits and the external review procedures as employers continue to get up to speed with these requirements and employees seek to enforce their rights under healthcare reform law. So moving away from the Supreme Court's decision and the DOL audit issues, I want to talk now for a few minutes about the current mandates that are coming into effect or that are in effect now or coming into effect very shortly. These are the mandates I'm going to discuss on the next few slides, so let me just get into them. Medical loss ratio rebates, those of you who are fully insured have likely received your rebate at this time if you're going to get one. Essentially, I'm sure most of you are aware of the standards for receiving a rebate, whether you're small group or large group. If you're a large group, your carrier had to spend 85 cents on the dollar on healthcare claims or health improvement activities. And if you're a small group, your carrier had to spend 80 cents on the dollar if you're fully insured. If they did not meet these minimum medical loss ratios, they were required to give a rebate, and that was required to be sent by August 1st. There was a lot of confusion initially when these MLR, medical loss ratio rebates, were first issued. I think it caught a lot of us by surprise because we just weren't expecting that there would be so many rebates at such a large value. But we've certainly had some of our larger clients getting rebates in the hundreds of thousands of dollars, if not more. And the rules governing distribution of those rebates, they're the plan asset rules under ERISA, and so they were written at least 30 years ago, if not more, and they didn't originally contemplate things like medical loss ratios. They were really written to deal with things like pension plan assets or demutualization proceeds, so it was a little unclear how these rules would apply to employer-sponsored group health plans. Luckily, the DOL gave us a little bit of technical guidance there, but it really was still pretty vague because these are all, the answer with respect to these loss ratios and these rebates really depend on the facts and circumstances. The general rule is that you apportion the rebate based on the employer and employee contribution ratio. The employers can simply retain the portion of the rebate that's not a plan asset, but the portion that is a plan asset must be used to benefit participants. Typically, this is done through a premium reduction. Importantly, the rebate must be used within 3 months of receipt by the employer, or the ERISA's trust rules apply, and you really don't want that to happen.